Hello, I'm Nida Ali, a barrister at Palm Court Chambers. Thank you for joining for the second part of our new practitioner series. Today's webinar is intended as a brief introduction to Part 36 of the CPR. Specifically, we shall be focusing on a few key provisions within Section 1 of the CPR at Part 36. Given the intrinsic complexity of Part 36, this webinar is by no means intended as a substitute for carefully considering Part 36 yourself and familiarizing yourself with the vast body of case law that's developed around it, but it is hopefully going to contribute to easing that process. Part 36 contains a self-contained procedural code for making offers to settle. We say self-contained because the manner in which Part 36 offers are made, varied, accepted, and or withdrawn are all dictated by CPR 36. Lord Justice Morbick, in the case of Gibbon and Manchester City Council, said its purpose is to encourage settlement and to enable those who make sensible offers to protect themselves against liability for the costs that are incurred in the continuation of proceedings to no ultimate advantage. It thus encourages genuine attempts at settlement by offering financial incentives in the form of cost protection to those who make realistic offers of settlement, whilst raising the financial stakes for parties who refuse reasonable offers. It succeeds, I would say, primarily by providing certainty in terms of both the nature and the effects of the offers that are being made under it, and the cost consequences that are likely to follow. Part 36 itself is divided into three sections. Section 1 contains general rules about Part 36 offers and how they operate. Section 2, as of the 1st of October 2023, with the extension of the fixed recoverable cost regime, now contains specific rules about Part 36 offers within fixed cost claims, specifically on the fast and intermediate tracks, and within fixed cost claims for noise-induced hearing loss. So essentially, claims falling within sections 6 to 8 of Part 45 of the CPR. It's important, of course, when talking about Section 2, to bear in mind the commencement provisions for the extended FRC regime, which is intended to apply and has begun to apply to most civil cases with a value of up to £100,000 that are issued on or after the 1st of October 2023. For personal injury claims, the extended FRC regime applies where the cause of action itself accrued on or after the 1st of October 2023. And for disease claims, it only applies when no letter of claim has been sent before the 1st of October 2023. Section 3 contains rules more about the offers to settle where the parties have either followed the RTA protocol or the employer's liability and public liability protocol. And at the same time, under either of those, they've started proceedings under Part 8. So, as mentioned earlier, the focus today is going to be Section 1, because while each of these sections undoubtedly merit their own lengthy webinar, we're going to start with the general position that's laid out quite helpfully in Section 1, and perhaps in future webinars can look at Sections 2 and 3. It's very important to bear in mind, though, when we're proceeding today, what is set out at CPR 36.21, which is essentially that the principles in Section 1 also apply to offers to settle which fall within Section 2, unless otherwise stated, but they do not apply to offers falling within Section 3. Now, Section 1 will, importantly, also continue to apply to, firstly, non-fixed cost fast track matters that predate the extended FRC regime. So those that were issued prior to the 1st of October 2023, as well as PI claims where the cause of action accrued prior to the 1st of October 2023. Secondly, it will also continue to apply to claims that are specifically excluded from the FRC regime. These are listed within CPR 26.910, and they're effectively claims that have to proceed on the multi-track. They include matters such as asbestos, lung disease claims, clinical negligence claims, other than intermediate track claims where both breach and causation are admitted, claim for damages in relation to harm, abuse, or neglect of or by children or vulnerable adults, specified actions against the police, as well as jury trials. Lastly, of course, all multi-track claims will, of course, continue to follow Section 1. As, of course, you'll know very well, Part 36 does not apply to small claims, so that's not a cause of concern for today. Moving on to our first key question: who can make a Part 36 offer and when? Now, CPR 36.2, subsection 3, says that a Part 36 offer may be made in respect of the whole or a part of, or any issue that arises in, a claim, a counterclaim, or other additional claim. I.e., any party to a claim can make a Part 36 offer, whether they're the claimant, the defendant, the Part 20 claimant, or the Part 20 defendant. But as we're going to go on to discuss, it's very important to make clear whether any offer that they make is intended as a claimant's offer or a defendant's offer. Equally, Part 36 offers can be made in respect of the whole, a part, or any issue that arises in an appeal or a cross appeal from a decision that's made at trial. It cannot, however, be made in relation to an appeal from an interim application. But when looking or when considering appeals, it's important especially to bear in mind CPR 36.4, which says that a Part 36 offer that's made in first instance proceedings does not follow through to any appeal. So an offerer will always need to make a fresh offer for the purpose of the appeal proceedings for those Part 36 cost consequences to attach. Now, Part 36 claims can also be made in respect of intended claims. CPR 35.71 talks about how a Part 36 offer may be made at any time, including prior to the commencement of proceedings. Of course, pre-issue Part 36 offers will bear the usual Part 36 consequences that take effect either upon acceptance or judgment having to be given. But further on the point of timing, I would just draw your attention to 35.72, which says that a Part 36 offer is made when it is served on the offeree. So this, of course, imports in the usual requirements for service of documents under Part 6. Now, the next thing to consider is how we make a valid Part 36 offer. CPR 36.5 crucially sets out what can be called the mandatory requirements or ingredients of a Part 36 offer. Whilst there is some scope in the case law for formal or technical defects within Part 36 offers to potentially be validated, it's very important to bear in mind that the mandatory requirements in CPR 36.5 must be complied with. Otherwise, the offer simply won't carry those critical cost consequences. So now let's take a closer look at CPR 36.51. A Part 36 offer must be in writing. This includes email, where there's been express confirmation that email communications will be accepted by the other side. It must make clear that it's made pursuant to Part 36, which is quite easily satisfied given that there's no prescribed wording that is required. It must specify a period of not less than 21 days within which the defendant will be liable for the claimant's cost, in accordance with Rule 36.13 or 36.23. It must also state whether it relates to the whole of a claim, a part of it, or to an issue that arises in it, and if so, to which part or issue. And lastly, it must state whether it takes into account any counterclaim. Now, CPR 36.52 clarifies that paragraph 1C does not apply if the offer is made late, i.e. if it's made less than 21 days before the start of a trial. Subsection 3 goes on to say how in appropriate cases a Part 36 offer must also contain such further information as is required by either Rule 36.18 relating to personal injury claims for future pecuniary loss, Rule 36.19 which relates to offers to settle a claim for provisional damages, and or Rule 36.20 which deals with the deduction of benefits. Now, Part 36 offer can be made using Form N242A. This isn't compulsory, but it is quite heavily advised because it helps avoid some of the common pitfalls. The form contains helpful guidance notes, including on the situation where offers are made on counterclaims or cross appeals. And it also reminds the user the importance of making clear whether it's intended as a claimant's or a dependent's offer, because of course, different cost consequences will attach. Now, whilst in previous cases, offers have often tried to draw upon the principle of estoppel to try and suggest that there's a clause within the offer itself that requires the offeree to notify the offerer if there's any defect or non-compliance with Part 36, and especially with 36.5. Justice Pepperell, in the case quoted there of Essex County Council and UBB Waste, in obiter dictum, but what quite clearly stated that estoppel should play no part in the Part 36 regime. The responsibility for ensuring that an offer is compliant with Part 36 should lie squarely upon the offerer and his lawyers. And now looking specifically at what CPR 36.5 has to say about terms regarding interest and costs. For interest, one of the mandatory requirements under Rule 36.5 is that a Part 36 offer must include all interest up to the end of the period specified under Rule 36.51c, i.e. until the end of the relevant period, or in the cases of offers that are made late, i.e. less than 21 days before trial, then for a period of 21 days. Accordingly, an offer that excludes interest is not a Part 36 offer. The effect of CPR 36.5, subsection 5, is that a Part 36 offer is deemed to be inclusive of all interest up to its acceptance, whenever that may be, unless its terms specifically provide otherwise. Now, where the offerer does choose to prescribe otherwise, they can only make specific provision for interest accruing after expiry of the relevant period, which of course would still clearly be worthwhile in a case of late acceptance. In terms of costs, including any terms as to costs is inconsistent with the scheme of Part 36 entirely. Likewise, an offer to pay a global sum that is inclusive of costs is not compliant with Part 36. Such offers will accordingly render any offer non-compliant and lead it to fall outside the Part 36 regime. Now, as well as the requirements of CPR 36.5, there are also two specific additional requirements for offers that are intended to be defendants' Part 36 offers. These are set out in CPR 36.6. Apologies. They firstly require that a defendant's Part 36 offer in settlement of a claim must be an offer to pay a single sum of money. And secondly, that the defendant's offer includes an offer to pay all or part of the sum at a date no later than 14 days following the date of acceptance. As if it doesn't comply with that, it will not be treated as a Part 36 offer unless the offeree nonetheless accepts the offer. Moving on to consider what this relevant period means, we have touched upon it briefly. It is defined in CPR 36.3, but it is effectively key to the operation of Part 36, especially as far as accepted offers go. So 36.3 G defines the relevant period. In the case of an offer that's made not less than 21 days before a trial, as being at least 21 days, as specified under Rule 36.51c, or such longer period as the parties may agree. Otherwise, the relevant period will be the period up until the end of such trial. When we're talking about that second circumstance, that of course relates to where the offer is made less than 21 days before a trial. So because a full 21 days cannot be allowed, the relevant period will simply run up until the end of trial. Now, Also remember that CPR 36.51c provided that the relevant period must be a period of not less than 21 days within which the defendant will be liable for the claimant's costs in accordance with CPR 3613 or CPR 36.23 if the offer is accepted. Now, this means that in any Part 36 offer that's made more than 21 days before trial, whether made by the claimant, the defendant, or a Part 20 party, it must contain a relevant period of a minimum of 21 days, during which, if the offeree, again, whichever party that may be, accepts the offer, the cost consequences will be that the defendant will pay the claimant's costs up until the date of acceptance. So that's quite pivotal there. Also remember that CPR 36.52 confirms that this requirement in paragraph 1c doesn't apply if the offer is made less than 21 days before the start of a trial. So in the case of late offers, that automatic entitlement to the claimant isn't there. And that's something we'll return to again a bit later. Again, because CPR 36 is designed to be a self-contained code, the court has no powers, either under CPR 36 itself or under Part 3.1, subsection 2A, which is often called upon, to vary this 21-day time period. It has to be done in accordance with what's set out in the provisions that we've just covered. So, prior to making its decision on an offeree may require clarification as to the terms of an offer. CPR 36.8 provides a mechanism for just this. 36.81 says that the offeree may, within 7 days of a Part 36 offer being made, request the offerer to clarify the offer. Subsection 2 says that if the offerer does not give the clarification requested, within 7 days of receiving the request, the offeree may, unless the trial has started, apply for an order that the offerer do so, and that would be done using the usual procedure in CPR 23. Subsection 3 goes on to say that if the court makes an order under paragraph 2, it must specify the date when the Part 36 offer is to be treated as having been made, because of course it'll be relevant or key to calculating that relevant period once again. It is important to bear in mind that if the offeree fails to seek such clarification, they may later be precluded from arguing that the offer contained insufficient information to allow them to, well, either for it to be valid altogether or to allow them to consider the offer itself. However, there's nothing within Part 36 that does say that while such queries or points of clarification are raised, the relevant period will be suspended. And that is one of the reasons for the 7-day limit. Suspension can be requested from the offerer, but of course, they're under no obligation to agree to that. But this also becomes relevant as far as consequences in terms of costs factor in. Because incomplete disclosure and the conduct of parties in respect of giving or refusing information is one of the factors that the court will be looking to take into account when it's considering whether or not to depart from the usual Part 36 consequences under Rule 36.17(5), which considers whether it would be unjust the usual cost consequences to apply. Now, CPR 36.9 and 36.10, although they are very important provisions, we're not going to cover them in too much detail, again, due to time constraints, but just a few headline points. A Part 36 offer remains open for acceptance until and unless its terms provide for it to automatically expire, if it hasn't already been accepted, at a given date or event following expiry of the relevant period, or it is withdrawn by the offerer in accordance with Rule 36.9 and 36.10. Now, a Part 36 offer can only be withdrawn or varied if the offeree has not previously served a notice of acceptance. A written notice of the withdrawal and or variation needs to be served on the offeree under any circumstances. And after expiry of the relevant period, a Part 36 offer that has not been accepted can be withdrawn or varied without the court's permission. However, especially in circumstances where a Part 36 offer is varied to make it more advantageous to the offeree, then it will take effect as a new offer with its own relevant period, and the original offer will remain open for acceptance alongside it. On the other hand, if the offerer wishes to withdraw their Part 36 offer or vary it to less advantageous terms for the offeree within the relevant period, then that's when CPR 36.10 kicks in and it has to be followed. And in that case, when you're varying a Part 36 offer to less advantageous terms, the original offer no longer remains open for acceptance. It will fall away and effectively be replaced in accordance with the provisions of CPR 3610. The key takeaway, I would say, from these two subsections of the rule is that you can make multiple Part 36 offers. You can have them open for acceptance at the same time. They can relate to the same or different parts of the claim or different issues within the claim. You can even withdraw and vary them as often as you like in accordance with CPR 36.9 and 36.10. But crucially, you have to keep them under review because as circumstances are changing, as more information is coming forward, you want to make sure you're not accidentally getting caught out by an offer that you've left open, because of course it could be accepted at any time. Moving on to consider acceptance itself, this is covered under 36.11. A Part 36 offer is accepted by serving written notice of acceptance on the offerer. There is no standard form for acceptance. The only requirement is that it must be in writing. Practice Direction 36, paragraph 3.1 does require that the notice of acceptance be both served and filed at court. The lesson in the case of Sutton Jigsaw Transport was to pay close attention to the service requirements in Part 6. Particularly in that case, it was Part 6.22 and 6.23 that were able to cause quite a bit of damage when they weren't followed to the letter. Now, CPR 36.11.2 says that subjects to paragraphs 3 and 4, which deal with the circumstances where the court's permission is required before a Part 36 offer can be accepted, and also subject to Rule 36.12, which adds additional caveats in respect of split trial cases. A Part 36 offer may be accepted at any time, whether or not the offeree has subsequently made a different offer, unless it has already been withdrawn. Now, the words whether or not the offeree has subsequently made a different offer stress that a counteroffer does not extinguish the original Part 36 offer, as it would do under usual contract law principles. The original offer will remain open for acceptance. Of course, even a Part 36 offer that has previously been expressly rejected can later be accepted. The offerer has to formally withdraw their offer in accordance with the provisions that we've just discussed, wherever there's no provision built in for it to automatically expire after a given period. Another situation that isn't set out here, when a Part 36 offer cannot be accepted, is where an offer is made in respect of a claim or a counterclaim that is subsequently either struck out or discontinued. Here the offer ceases to be effective and it's simply no longer open for acceptance. And that's because Part 36 is concerned with the settlement of existing claims. So even though you can make a Part 36 offer pre-commencement, if the claim later falls away entirely due to being struck out or discontinued, so do the usual Part 36 consequences that may have otherwise applied. So I guess the takeaway there is that when 36.11 says any time, it means any time in which a claim continues to subsist between those two parties. And the case quoted there, quite interestingly, when the claimant, in the case of Joyce, subsequently managed to obtain relief from sanctions and had their claim reinstated, with it, the Part 36 offer again became capable of acceptance. So it's simply about being in proceedings. Moving on to consider the circumstances in which the court's permission is required to accept a Part 36 offer. Those are listed within 36.11.3, and they are Rule 36.15, subsection 4, which deals with offers made by some, but not all, of the multiple defendants in a claim. Secondly, cases that fall within Rule 36.20, subsection 3b, and that applies where the deduction of benefits and lump sum payments need to be considered. Another sort of claim in which the court's permission will be required before a Part 36 offer can be accepted is where there's been any sort of apportionment or one is required under CPR 41.3a in proceedings under the Fatal Accidents Act and the Law Reform Act 1934, or most commonly and most relevant to our purposes perhaps, where a trial is in progress. Definitions are again for CPR 36 provided within Rule 36.3, and this says that a trial means a trial in a case, whether it's a trial of all issues or only of one particular issue, such as liability or quantum, and a trial is in progress from when it starts until when judgment is given. So if you're trying to accept a Part 36 offer within that period, that's when you will need to be asking the court for permission. But you should be wary, because permission in those circumstances will very rarely be given. It's simply, the position in case law is to allow a party to accept an offer mid-trial can be quite prejudicial, because at that point they've of course had the advantage of seeing which way the wind is blowing, which is how it's referred to in case law. But one further situation, of course, where permission will be required is where the claimant is a child or a protected party, and that's the usual provision, of course, under Rule 2110. Now, Practice Direction 36, at paragraph 3.3 does say that unless parties agree otherwise, applications for permission to accept a Part 36 offer will need to be made in accordance with Part 23 and be dealt with by a judge other than the allocated trial judge, if there is one, or they'll have to be raised at a trial other than at any trial other than a hearing that's not before the trial judge. Now, where the court does give permission under paragraph 3, unless all parties have agreed costs, the court will then have to go on to make an order dealing with costs, and as to whether or not those consequences in 36.13 will apply. Coming on to CPR 36.12, we'll touch upon this very briefly. There is a very large amount of case law in relation to split trials and how they basically operate when they come under the regime of Rule 36. It applies in any case where there's been a trial, but all the issues have not yet been determined, i.e. liability may have been decided, but quantum may be pending, which is quite often the case. It says in subsection 2 that any Part 36 offer which relates only to parts of the claim or issues that have already been decided can of course no longer be accepted. But the point is simply that such offers need not be withdrawn, and they can later still be relied upon under Rule 36.17. Subsection 3 says that subject to paragraph 2, and unless the parties agree, any other Part 36 offer cannot be accepted earlier than 7 clear days after judgment is given in such a trial. And the purpose here is simply to give the offerer that fixed 7-day window in which they can reassess the situation following whatever outcome has occurred in the trial that's taken place, and decide whether they need to be serving a notice of withdrawal or variation. Now, this provision expressly dealing with split trials was introduced to address various problems that had arisen under the previous regime. And what it effectively allows judges to do is address these cost consequences of Part 36 offers relating to the issues that they have already determined. Although in practice, they'll often still be unwilling to do so, and they would prefer for all issues to be determined. But of course, it depends on the judge on the day. Now, cost consequences of acceptance of a Part 36 offer is, of course, the crux of it all. This, along with 36.17, that we'll go on to consider. this begins to lay out the whole carrot and stick approach that Part 36 operates on the basis of. It's important to bear in mind that while we're looking at CPR 36.13 in relation to the consequences of acceptance, in the event of claims that come in to the ambit of the extended FRC regime, it's CPR 36.23 that will be applying. Now, the cost consequences that are available upon, under CPR 36 depend on which party makes the offer, whether the offer is accepted. If it is accepted, then when it's accepted. And if it's not accepted, then what happens at trial or summary judgment. CPR 36.13 draws a distinction between the costs consequences of acceptance of a Part 36 offer that's accepted within the relevant period, and such consequences that would arise when an offer is accepted after expiry of the relevant period. The general rule, as laid out there under CPR 36.13, is that where a Part 36 offer is accepted within the relevant period, then regardless of who made the offer, the claimant will be entitled to the cost of the proceedings, including their recoverable pre-action costs, up to the date on which notice of acceptance was served on the offeror. Now, we did touch upon that previously, but there are exceptions, and the first exception is in CPR 36.13(2), which provides that where a defendant's Part 36 offer relates to part only of the claim, and at the time of serving notice of acceptance within the relevant period, the claimant abandons the balance of the claim, the claimant will only be entitled to the cost of such part of the claim unless the court orders otherwise. That is effectively reverse the position under the previous rules, as the change that Lord Justice Coulson has described as more closely according with simple justice. And I think that comes across quite intuitively as well. CPR 36.13(3, where recoverable costs are subject to the fixed cost regime contained in Part 45, it's the provisions of that rule that will prevail. Otherwise, some key points to note are that under both the general rule in 36.13(1 and the exception quoted there under 36.13(2, costs are to be assessed on the standard basis, if not agreed. The claimant's costs will include any costs incurred in dealing with the defendant's counterclaim, provided that the Part 36 offer said that they would. And where the claimant accepts any offer made by the defendant to pay a single sum, the defendant must pay the sum offered in settlement within 14 days of acceptance. And if they don't, there are certain consequences that we can come on to. Now, the second exception to that general rule that we've just covered is set out in CPR 35.134, and it effectively lists out three situations in which the liability for costs must be determined by the court, unless the parties agree otherwise. Now, these situations are A, where the accepted Part 36 offer was made late, i.e. it was made less than 21 days before the start of a trial. So, as mentioned earlier, there is no automatic cost order upon acceptance of a late offer. Instead, it's the court that has to decide the appropriate cost order if the parties cannot agree liability for costs. B, a Part 36 offer relating to the whole of the claim is accepted late, i.e. it's accepted after expiry of the relevant period. Or C, a Part 36 offer which does not relate to the whole of the claim is accepted at any time and is not covered by the first exception that we've just read in 36.13(2). Now, in relation to subparagraphs 4A and C, CPR 36 does not actually specify how the court should go about determining cost liability. There isn't really an established body of case law over it either, which would lead to the presumption that the court will simply be following the usual approach under Rule 44.2. But what CPR 36.13 subsection 5 does do is that it makes express provision for cases that fall within CPR 36.13(4)(b). So those instances where there's a late acceptance of an offer relating to the whole of the claim. And it provides that in the absence of the parties agreeing, the court must, unless it considers it unjust to do so, order that the claimant be awarded costs up to the date on which the relevant period expired, and that the offeree pay the offerer's costs from the date of expiry of the relevant period up until the date of acceptance. Now, the offeree is effectively penalized for not accepting the Part 36 offer within the relevant period by being required to pay the costs that have been incurred by the other side since its expiry. But again, note, even where a Part 36 offer is being accepted outside that crucial relevant period, there is no presumption that costs are to be paid on the indemnity basis. Rather, costs will be paid on the standard basis unless the receiving party is awarded indemnity costs under the conventional principles, which of course always remain open to the court to award. And there's relevant case authorities on the screen confirm that. So we now need to delve a bit deeper into what it means with the wording, unless it considers it unjust. CPR 36.136 says that in considering whether it be unjust to make the order specified in 36.13.5, the court must take into account all the circumstances of the case, including the matters listed in Rule 36.17.5. Now, these matters are the terms of any Part 36 offer, the stage in the proceedings when any Part 36 offer was made, including in particular how long before the trial began, the information available to the parties at the time when the Part 36 offer was made, the conduct of the parties with regard to the giving or refusal to give information for the purposes of enabling the offer to be evaluated, and whether or not the offer was a genuine attempt to settle the proceedings. The court's discretion to disapply the usual Part 36 cost consequences on the grounds that it would be unjust applies both to late acceptance of Part 36 offers, as we're covering now, but also unaccepted Part 36 offers under Rule 36.17, as we're going to come on to. And what it does is it reflects what was already an existing approach under previous case law and has codified it. And it takes consideration of the usual of the usual factors that are involved in applying the general rule whenever making any order as to costs under Rule 44.2, subsection 4. Now, in terms of the burden of adducing evidence to establish that making the orders would be unjust, the burden will lie fully with the offeree, unsurprisingly, because they're the ones who will be seeking to have the default Part 36 consequences disapplied. The test, however, is one of injustice. It's not simply enough to say that it would have been difficult at the time to form a view on the outcome of the litigation. It has to be shown that it would be unjust to allow those consequences to come into fruition. Now, unless it considers it unjust, it is the sort of phrasing that unsurprisingly has attracted a substantial body of case law to better explain effectively what the courts require. In the case of Smith and Trafford Housing Trust, Justice Briggs summarized the applicable principles, adding that the burden on the claimant who has failed to beat the defendant's Part 36 offer to show injustice is a formidable obstacle to the obtaining of a different cost order. If that were not so, then the salutary purpose of Part 36 in promoting compromise and the avoidance of unnecessary expenditure of costs and court time would be undermined. In Factortame, Lord Justice Walker spoke of how the court should be trying to assess who in reality is the unsuccessful party and who has been responsible for the fact that costs have been incurred which could otherwise have been avoided. In the case of Lillyman, Justice Briggs set out the four specific considerations that have been identified in 4A to D disclose a common thread which focuses the injustice analysis upon the circumstances of the making of the offer and the provision or otherwise of relevant information in relation to it, rather than upon the general conduct of the proceedings by the parties. Nonetheless, I consider that the requirement to take into account all the circumstances of the case does enable the court to take a broader view in an appropriate case, so that it is not entirely disabled from having regard to questions of justice or injustice, arising from the manner in which the offering party has made use of its cost expenditure. So some quite helpful authorities there. I have listed two more cases there. One of those is head and the culprit heating. Interestingly, the decisive factor in that case, when considering all the circumstances, was simply the later introduction of the claimant's evidence and what that meant for the defendant being able to evaluate the offer that had been put. The further case of Downing and Peterborough. So David Ely observed that it is elementary that a judge Sorry, Andy, if I might start both of those cases again. Apologies. I've included two further cases there, head and the culprit heating, which is in which the decisive factor when considering all the circumstances was the late introduction of the claimant's evidence, which led to their costs not being awarded despite them succeeding at trial. And Downing and Peterborough and Stanford Hospital's NHS Foundations Trust, in which Sir David Ely observed that it is elementary that a judge who is asked to depart from the norm on the grounds that it would be unjust not to do so should not be tempted to make an exception merely because he or she thinks the regime itself is harsh or unjust. There must be something about the particular circumstances of the case which take it out of the norm. There is much more case law out there, but I think these authorities do a good job of summarizing some of the key ways in which the courts have tried to approach this test. Unsurprisingly, the other limb of the test that has led to some trouble is where the test asks whether there's been a genuine attempt to settle the proceedings. For this, I would advise viewers to have a look at the judgment in Huck and Robson, the 2002 case, considers this issue in some depth. But I think most helpfully, Judge Henderson dealt with it in A, B, and C, D. He said the concept of an offer to settle is nowhere defined in Part 36. I think it's clear, however, that a request to a defendant to submit to a judgment for the entirety of the relief sought by the claimant cannot be an offer to settle within the meaning of Part 36. If it were otherwise, any claimant could obtain the favorable consequences of a successful Part 36 offer, including the award of indemnity costs, by the simple expedient of making an offer which required total capitulation by the defendant. In my judgment, the offer must contain some genuine element of concession on part of the claimant, to which significant value can be attached in the context of the litigation. The concept of a settlement must, by its very nature, involve an element of give and take. A so-called settlement, which was all take and no give, would, in my view, be a contradiction in terms. And that is generally the view that's been upheld in the authorities. The purpose, of course, of this limb is to allow judges to consider whether offers that effectively appear nominal in nature or offer no substantive concession, such that the defendant would inevitably reject them, should attract the Part 36 cost consequences. Because, of course, if they're merely being used as a tactical step to try and secure these Part 36 consequences, then it couldn't be in the interest of justice to allow that. I've included on the next slide a few examples on how the courts have approached this test in various cases. Again, there's plenty of other case authorities out there, but I do think these represent an interesting range. And there's some that I'll allow you to go through in your own time. But a key point to bear in mind is that the analysis is very fact-specific. Coming on to some of the other effects of acceptance of a Part 36 offer. CPR 36.14 provides relatively straightforward provisions for stay and enforcement. In subparagraphs 1 to 4, it set out how a claim on which a Part 36 offer is accepted, or the relevant part thereof, will be stayed following acceptance, and where the court's approval is required before a settlement can be binding. For example, where there's a child or a protected party involved. then the stay will take effect only after the court has approved the settlement in the usual manner. Subparagraph 5 confirms how any stay would not affect the court's power to enforce the settlement terms or deal with costs. Subparagraph 6 underscores how when a Part 36 offer that includes an offer to pay or accept a single sum of money is accepted, that sum must be paid to the claimant within 14 days of acceptance or relevant order under Rule 41.2 or Rule 41.8 where appropriate, unless the parties agree or the court order provides otherwise. Now, in this sense, it's important to remember that a counterclaiming defendant is treated as a claimant in respect of any counterclaim. Apologies. It's important to remember that a counterclaiming defendant is treated as a claimant in respect of any counterclaim. In the case of Titmus and General Motors, it was reiterated that the court has no jurisdiction to extend this 14-day period, again, under CPR Part 3, because Part 36 is a self-contained code. The importance of subparagraph 6 is made clear by subparagraph 7, which effectively allows the claimant to enter judgment for the unpaid sum if it remains unpaid after that specified period, and they can then proceed to enforce the order in the usual manner. Subparagraph 8 addresses non-monetary Part 36 terms, providing that where one party has not honored the accepted terms of the offer, the other party may apply to enforce by applying to the court without the need for a new claim to be initiated. Again, CPR 36.15 and 36.16 are two sections that I am not going to cover in too much depth here, but they cover, respectively, what happens in the case of acceptance of a Part 36 offer made by one or more, but not all of the defendants. And in relation to the latter, restriction on disclosure of a Part 36 offer. In relation to 36.16, I will just point out that the rule first sets out that Part 36 offers are to be treated, quite unsurprisingly, as without prejudice except as to costs, before going on to set out what may be disclosed and under what circumstances. That is why very often when a Part 23 application is needing to be made under some of the provisions that we've discussed, arrangements will have to be requested to ensure that it's not before the allocated trial judge, if there is one in this case. Moving on to the last provision that we're going to consider in some detail, and that is CPR 36.17. And these are the cost consequences that take effect following judgment. Now, again, for claims that come within the extended fixed recoverable cost regime, Rule 36.17 applies subject to the provisions of Rule 36.24. This, I would respectfully say, is the most pivotal provision of Part 36. It includes the incentives intended to encourage reasonable offers of settlement. I'm actually going to begin with 36.17.2, which says that for subparagraph 1, in relation to any money claim or money element of a claim, more advantageous means better in money terms by any amount, however small, and at least as advantageous shall be construed accordingly. A few points to note in relation to this. The comparison in money terms is made at the date of judgment. Hence, that is the rate at which any judgment in the foreign currency will need to be converted into sterling at. The case of Paransing confirmed that as Part 36 offers are deemed to include interest up until the end of the relevant period, in accordance with Rule 36.54, interest after that date must be ignored when you're quantifying whether or not an offer is more advantageous or at least as advantageous. Equally, the Lehman Brothers International Authority confirmed that in non-monetary cases, a more open-textured approach is required that permits a more wide-ranging review of all the facts and circumstances of the case. Now, coming on to CPR 36.17.1, this applies where upon judgment being entered, A claimant fails to obtain a judgment that is more advantageous than a defendant's Part 36 offer, i.e., the claimant fails to beat the defendant's Part 36 offer at trial. Or B, the judgment against the defendant is at least as advantageous to the claimant as the proposals contained in a claimant's Part 36 offer, i.e., the claimant beats or at least matches their own offer at trial. And those are the two distinct circumstances that this paragraph looks at. CPR 36.17(3) says, in relation to the situation in Rule 36.17(1)(a), i.e., that first situation, subject to those exclusions in subparagraphs 7 and 8, the court must, unless it considers it unjust to do so, order that the defendant is entitled to costs, including any recoverable pre-action costs from the date on which the relevant period expired, and interest on those costs. So that creates quite a similar situation to that created upon acceptance in CPR 36.13, subsection 5, except that now the offerer, in this case the defendant, will also be entitled to pre-action costs, and express provision is provided for interest on their costs. The case of Murphy set out how a successful defendant cannot claim interest above the ordinary commercial rate on costs, even where the claimant fails to obtain a judgment that is more advantageous than the offer. Such costs will again usually be on the standard basis, but they could be on the indemnity basis, if appropriate, upon applying the court's usual discretion under Rule 44.3. The earlier principles and the authorities that we discussed in relation to whether it would be an unjust outcome that the court needs to disapply are equally relevant when the court is considering this test under Rule 36.73. Subparagraph 8 of CPR 36.17 simply confirms that soft tissue injury claims come under Rule 36.21 and do not attract the consequences set out in this paragraph. Now, the other situation, of course, is that set out in CPR 36.17(4), and this is a real biter, effectively. This says that where paragraph 1b applies, so the claimant has effectively at least matched or beaten their own offer, the court must, unless it considers it unjust to do so, order that the claimant is entitled to interest on the whole or part of any sum of money, excluding interest that has been awarded, at a rate not exceeding 10% above base rate for some or all of the period starting with the date on which the relevant period expired. So this is effectively enhanced interest, as it's referred to in the case law. And subparagraph 6 provides that where the court also awards interest under any other power on the same sum and for the same period, it's the total rate that must not exceed above 10% above base rate. Subparagraph B sets out that the claimant is also entitled to costs, including any recoverable pre-action costs, on the indemnity basis from the date on which the relevant period expired. In the case of East West Corp that I have quoted it on the slide, Justice Thomas said at paragraph 14 that the purpose of the indemnity basis of costs here is to compensate the claimant and to bring home to the defendant that the risks that they have run of not accepting that very reasonable offer that was put to them. Under subparagraph C, the claimant is also entitled to interest on those costs at a rate not exceeding 10% above base rate. The authority of OMW Petrum, in that case, Sir Geoffrey was clarified that the award under subparagraph C was not purely compensatory, and taking into account various factors in that case, but principally the defendant's dishonest and unreasonable defense in the face of a reasonable settlement offer that was put to them by the claimant, the Court of Appeal did go on to order interest at the maximum 10% over base rate provision. Lastly, the claimant, is also entitled under subparagraph D to an additional amount. And this is explained as follows: provided that the case has been decided and there has not been a previous order under this subparagraph, an additional amount which shall not exceed £75,000, calculated by applying the prescribed percentage set out in the sum, either the sum awarded to the claimant by the court, or where there is no monetary award, and the costs awarded by the claimant by the court. And there's a table, of course, that accompanies this subparagraph that sets out how that percentage is calculated. Now, this additional amount should be assessed as a percentage of the award, including interest that has been awarded, but for the Part 36 offer. Now, a question that commonly arises when looking at how extensive this provision is whether all four enhancements have to be permitted by the court on every occasion where it's proceeded to trial and the claimant has at least matched their own Part 36 offer. And what Justice Stewart said in the case of JLE and Warrington, he agreed that it was open to the court to make only some of the orders, but he observed that it would be unusual for the circumstances to yield a different result for some only of the orders. So effectively, while it can be done, there's nothing in the rule which undermines or lessens entitlement to some or other of those enhancements. So the rewards tend to be treated as a composite package. CPR 36.17, subparagraph 7 sets out that paragraphs 3 and 4 will not apply to an offer that has been withdrawn, quite understandably. One that has been changed so that its terms are less advantageous to the offeree, where the offeree has beaten the less advantageous offer. Or C, to an offer that was made late, effectively that was made less than 21 days before trial, unless the court has abridged the relevant period. In the case of such late offers, an application to abridge should be made as soon as possible. This will ensure, as far as possible, that costs can potentially still be saved to some extent, and that both parties will know whether or not there's a compliant Part 36 offer available to them, and accordingly, what cost consequences will attach to that. Any application that is being made in this regard would be made under CPR 23 in the usual manner. But given the disclosure provision within Rule 36.16, abridgment should be dealt with by way of an interim application, again before a different judge to a trial judge, to prevent it affecting the proceedings.